We are starting with a series of adjustment of status videos. Wherever we are going to talk a little bit about removal proceedings and what to do when a PD request has been denied. But before we get into the subject, I want to advise a little bit on what to do exactly in removal proceedings when a person finds themselves in removal proceedings. My name is Bijoux, Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, we do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases every day. If you're new to my channel, please go ahead, subscribe, hit the notification bell so you don't miss out on anything. Enjoy the content. You go ahead and like, share. Don't forget to comment below. Also follow me on all platforms. Links are in the description box. Let's get right into it. PD request denied. What exactly should I do? Well, before we get into the PD request denial, the reason, first of all, a person has a court order being order removed, it's because they didn't meet the requirements of the benefits that they were asking for in removal proceedings, or maybe they are subject of removal based on either overstayed visa, criminal acts, or just something that led them to be deportable or inadmissible. If you are in removal proceedings, the first thing you have to do is to really assess your case. Talk to a qualified immigration lawyer to assess your case to really know whether you have a strong case or you have a weak case. Because if you have a weak case, what's gonna end up is the person's gonna be order removed. They might appeal the decision of the immigration judge, but just know that out of 10 cases, maybe 2 cases or maybe only 1 case get a positive outcome at the BIA, the Board of Immigration Appeal. It's really hard to basically overturn a decision of an immigration judge, especially in weak cases. So what are we advising? When we look at the case and determine whether it's really weak, you don't have sufficient evidence, no credibility, stuff like that, we will advise to ask for a dismissal. Ask for ICE to exercise prosecutorial discretion on your behalf and just dismiss the case. If they offer it, especially when they offer it, you should just take it. Considering other facts, right? Let's say you have a child who's a U.S. citizen and the child is 17, and you basically in 4 years, the child is going to turn 21. What exactly can you do? In that case, if ICE offers you a dismissal, you have to take it. Why? Chances are, if the case doesn't go your way, you're gonna be order removed. And once you've been order removed, you appeal, and the Board of Immigration Appeals maintain the decision of the immigration judge, then you're gonna be stuck with an order of removal. And to reopen that case when the child turned 21, that's not an easy thing to do. The best way to go about it is to just take the dismissal or ask for a dismissal if they can do it. If they cannot, maybe an administrative closure will be another best scenario. That way you can keep a work permit while we wait for the child to turn 21. If not, dismissal is a best idea, because even though you might not have a work permit within 4 years of the child turning 21, however, once the child turning 21, depending on the way by which you enter the United States, you might be eligible to adjust status. Just think about it. 4 years without work permit and being able to adjust status in 4 years, or have an order of removal that you do not know when ICE will agree to reopen the case, or if the immigration judge will agree to reopen the case, even though you have a new relief available. We've seen cases where people have their spouses that are U.S. citizens, they have children who are U.S. citizens, but because they have been ordered removed, they cannot reopen the case because ICE doesn't agree with it. or maybe they go directly to the judge and the judge deny, they go to appeal, deny, then you're stuck in a limbo. But you could have done it the other way around, take a dismissal or administrative closure, especially when it's available. You look at the wiki case, you look at administrative closures available, you look at dismissals available, take those two, or either take those other two options. It's better than try to fight a case that is weak, lacks credibility, lacks evidence, sufficient evidence to overturn those decisions or to make you win a case. Well, it's just not the best strategy, okay? So, and then that's why denial of PD requests happen later on in the process after a person has been ordered removed. And once it is denied, what do? You try again, or you go file for a motion sua sponte based on availability of new relief and hope for the best, which is a difficult task and very expensive one. So if you are in removal and you're trying to decide whether to fight this asylum case, or whether to fight cancellation of removal, or whether to take a dismissal or administratively close your case, let us know. Let us know so we can assess your case and try to see if we can help you make a better decision under your specific circumstances. 202-751-2180. Consultation fees apply as usual. You can schedule the consultation by clicking the link in the description box. Until next time, bye-bye.